All right, we welcome the students, the fifth grade students from Montezuma. Thank you so much for being with us this afternoon, and thank you to your teachers, students, for arranging you to be in our building today. Next case is State versus Coleman, and Ms. Meier, you may proceed.
Thank you, Justices. My name is Micki Meier. I've been practicing for 2.5 years, primarily out of Scott County. And I am here, and I apologize, may it please the court, may it please counsel. I am here representing Mr. Coleman. Mr. Coleman comes to you via a traffic stop that was initiated. Our position is very simple. Our argument is once probable cause dissipates, once the mission is completed at a traffic stop, the officer should then basically walk away. And Mr. Coleman was stopped. He was stopped because the vehicle was registered to a driver who was barred or suspended. After that happened, the officer walked up to the vehicle knowing that the registered driver was a female. Once he got to the vehicle, he realized that the person that was actually driving the vehicle was a male. At that time, our position is, again, probable cause had dissipated, the mission had stopped, had ended. The officer should have said, apologize about the confusion, walked away, and gone on with his day.
Counsel, agree that the stop itself was lawful?
Yes, I do.
Okay. Would we have to overrule State v. Jackson in order to for your client to win today?
I do believe that you would have to. I believe that State versus Jackson basically says that an officer is permitted to ask for general information, ID, insurance, etc. So I do believe that you would have to overrule Jackson.
But didn't the U.S. Supreme Court in Rodriguez and our court in Pardee also acknowledge that the mission of the officer can include asking for routine documents, including asking for a driver's license? What's wrong with allowing that?
Your Honor, back to the very basic argument, which is once probable cause had ended, once the officer walked to the vehicle and said, oh, I'm sorry, you're a male, clearly you're not the person that I'm looking for, probable cause is over, and you don't get to asking for the identification question. However, to answer your question, I believe that the other case law, and I'm asking this court to go outside and look at other jurisdictions and see that in other jurisdictions this tends to be a trend that officers are no longer being allowed to ask for additional information.
You know, between your brief and the Court of Appeals, there's quite a string side of other states that say you can't go on to ask the license, or ask for the license if you're done with the business that prompted the stop. But most of those were preceded Rodriguez, which talked about the officer can ask for the paperwork. And we've got an Iowa statute that requires all of us to carry our driver's license on us when we're driving. How do you get around that?
I understand, Your Honor, and frankly, I just don't think that we get there. I think that as soon as the probable cause is over, that the officer must walk away simply because the U.S. Constitution as well as the Iowa Constitution.
But let me say, by that logic, in Pardee, I mean, I remember it pretty well because I wrote the majority. By that logic, once the officer had decided he was just going to write a warning, which he actually decided, I think, right at the beginning of the stop, he was never ever going to really write a ticket, he should have let those two fellas go. And I indicated, based on Rodriguez, that the officer could detain them long enough, at least, to do the normal traffic checks, the driver's license, the looking for warrants, the registration, the proof of insurance. And a couple of my colleagues indicated they felt he could have been detained even longer than that. So, how do you square your position with what we said in Pardee?
Yes, Justice. So, in responding to that, I guess, I'm gonna have to ask you to go outside, and look at some of the other jurisdictions, that say that prolonging a stop long enough to ask for a driver's license and, an insurance card simply is too long. And, there is no need to ask for those items. There's, in the other jurisdictions, no requirement to ask for those items because it just prolongs the stop. And so,
Well, in Part E, there was a violation, a couple violations. I think I referred to as mundane, and they were. But the violations were live wires when the officers checked outstanding driver's license, so forth. Here, if I understand the facts, there was no live wire violation once it was determined that the driver was a male.
that's
right?
correct, Justice. So with that being said, my client was pulled over simply because the registered driver, had a suspended driver's license or a barred driver's license. So the officer went into the stop with the understanding or with the idea that the registered driver would be the person that was driving the vehicle, therefore committing a traffic violation because she did not have a driver's license at that time. So there were no other issues as far as the traffic stop was concerned, no.
I realize you weren't Mr. Coleman's lawyer at the time the motion to suppress was filed, but was the Iowa Constitution argued at the trial court level?
I am not sure of that question. I would have to go back and look at my notes to be 100% for sure that the Iowa Constitution was argued at that time.
Was the
If
federal
it wasn't-
Constitution argued?
I believe so because under the I believe that I cited in my application for further review that was argued at that time. But again, I'd have to go back and look at my notes to be 100% for sure.
I mean, so what's your position on preserving an Iowa constitutional issue? Has it been waived because it wasn't presented before the district court?
Well, I could understand where there could certainly be an issue there. However, I think at this time when I'm asking for further review and at the Court of Appeals, that would pull it into play. However, I do understand that position.
I read the transcript of the motion to suppress. They didn't cite any constitution.
Okay.
But I believe the motion to suppress referred to both constitutions. And the court didn't make that distinction when it decided the case. Am I off on that, or?
Again, I would have to go back and read see the transcript again to be 100% positive to be able to answer that question.
What do you make of the fact that in the Cumming case, the United States Supreme Court reversed the Illinois Supreme Court on basically a factual scenario that was pretty similar to this one? Doesn't that suggest that the United States Supreme Court thought that this factual scenario is covered by the Rodriguez language that says officers can perform the routine traffic checks after they make a stop?
In my notes, as far as Cummings is concerned, I have that they found that asking for the identification was too long. However, I could be wrong on that issue, but when I interpret Cummings, asking for identification would be too long or any prolonging of that particular stop would violate the Constitution.
I think you were right as to Cummings 1, and then the U.S. Supreme Court vacated that and sent it back to decide it again in light of Rodriguez. And when the Illinois Supreme Court decided at Cummings 2, they upheld the stop and the request for the driver's license.
And as far as that question is concerned, I can look at the other jurisdictions and again see that requesting the driver's license just simply exceeds the scope for probable cause.
How long, does our record in today's case tell us how long it takes to ask somebody to show them their driver's license?
It doesn't take long, and in fact, in one of the cases, there was a discussion about how long it would take for an actual traffic stop to take place and how long it would take for identification. Presumably, it would not take a very long time. However, you know, again, our position is simply that the probable cause ends upon learning the gender of the driver. And at that point, the officer should say, sorry about your trouble, and send John your way. Going back to some of the other cases, the purpose of the stop for that particular person was, again, to identify that the female driver who was licensed, or the registered owner, did not have a driver's license. So that is what the officer pulled up on his screen, and so that was the purpose of the stop. And once learning the gender, the purpose of the stop would, again, dissipate the probable cause, and then that would allow the officer to send my client on his way. And again, as you had mentioned, there was no other traffic violation that happened. Mr. Coleman had not swerved to miss something in the road. Mr. Coleman had properly displayed license plates. There was no other purpose for the stop except to identify.
This was a stop of a black man in a 98% white community. Is there any evidence that this stop was pretextual, or was this officer out there just stopping anybody that was bad? Did anybody ever develop that?
I don't think it was ever developed in the record, and I don't believe that to be the case. In fact, I know personally the officer that pulled him over, and I don't believe that to be the case. And again, it was not developed in the record, so no.
Didn't the officer say he couldn't see the driver? It was night, and didn't realize it was a man until he walked up to the car?
Yes, that is the case. And that's also the case when you go back to Cummings, I believe, because that person actually sat back in the vehicle, kind of concealing his identity. And so when the officer went in, the officer could see, obviously, this is a male and not the person that we're looking for. So I'll basically wrap up my argument here, and again, the question is simple to us, and that is, what is an officer to do when he's faced with the end of a probable cause situation? Our argument is asking for identification, asking for an insurance card goes too far. The officer should have walked away once probable cause had ended, and we would ask that you overturn Jackson from 1982 and revisit the issue in Iowa, and again take another look at Parody and Rodriguez and Cummings, and look outside of these particular cases and even look further into some of the other jurisdictions.
Thank you, Ms. Meier.
Thank you.
Mr. Mullins.
Good afternoon. May it please the court.
Can you
I
help me
mean-
out before you start? I had a chance to refresh my memory here, and I read the motion to suppress, didn't cite any Constitution. Read the transcript, didn't cite any Constitution, but said the Supreme Court has ruled against me in the past. I think the defense attorney said that, and I think it was referring to the case they're asking to be overturned. And then the ruling of the judge is one sentence or two sentences, that there's probable cause with no explanation. So what constitutions are we dealing with on this issue? The federal, the state, both, one? I mean, what are our parameters in deciding the case?
Let's go with the constitutional provisions that were briefed and argued on appeal, and that's just the Fourth Amendment.
Mention Article 1, Section 8 on appeal at all?
No. And by the way, in the district court, and not to throw stones, but though we all know I've done that often enough, the reference to probable cause is beside the point, and in fact, it's factually off because they said that that the driver wasn't suspended, and we in fact know that's true. So we do find ourselves in a position where we have to grapple with the Fourth Amendment issue, as guided by Rodriguez and Pardee, because we really have an undeveloped state constitutional claim.
Well,
I could say it's not even before us, I take it. I mean, your view is, aside from what happened at trial, it's ambiguous at trial, but on appeal, you say the state constitution has been mentioned and therefore it's not part of the case, if I understand correctly.
Yes.
Okay.
But to
But on
put
the-
some facts to that, let me,
But on the appellant's brief, they say a traffic stop is a seizure in the United States Constitution and the Iowa Constitution. That's the only reference to any constitution in the whole brief, and they talk about both. They don't talk about the Fourth Amendment in their brief. There's no cite to it.
well, then we're,
And let me just add, some of the cases they say from other states were done under their state constitution, if I remember right.
I know for sure that one of them rejected a state constitutional claim. That was Cummings. I don't know if any of the other states were decided concurrently on both, but I think it ought to be fair enough to say that there was not much in the way of a development of all of the work that you would typically wish to see in a state constitutional claim, neither below nor on appeal.
Sure, I think that's right. But do we consider the argument that was actually raised under the Iowa Constitution? I mean, the argument that was raised is a simple one, really, and that is that once the suspicion with respect to registration evaporated when you could see that it was a male driver, then you have to allow the vehicle to go on its way. I mean, that argument was raised, and shouldn't we consider that under the Iowa Constitution then?
No.
Why is that, again?
It's a two-part. One, and I know we've locked horns on this issue before, but in my view, there's an error preservation question based on what occurred in the district court. And the court has in the past disagreed with me, I know, that if that reference to something that rhymes with Constitution preserves both documents.
Because we don't know it's a federal constitutional claim. We don't know that the federal constitutional claim was raised, as I understand the state of the pleading. I mean,
Let me
and
make it worse. I
then-
want to interrupt you for that. Let me make it worse. You argue the state constitution. You argued that under the state constitution, it's not a violation
And-
in your brief.
Right. And then.
But you don't say it wasn't preserved. You just argued it wasn't. You don't argue it wasn't preserved. You argued the state constitution won't allow it either. That's
I
on
don't believe
page
I said
4 of
the
your
state
brief.
Constitution wouldn't allow the.
You just say as a general rule, they should be considered consistent with each other, so you want to interpret the same way as the federal constitution. And I don't think we're bound by that, are we?
No. But if I can, let me just say this. We have error preservation, which is both a factual and a legal issue that we see either happen or not happen in district courts. And then we have a development issue, otherwise on appeal, which has more in the nature of a waiver, okay? So has the appellant affirmatively advanced a divergent state constitutional claim? And they haven't here. They have not asked for a divergent result under the state
but what they
constitution.
have asked for under the state constitution is that once the reasonable suspicion of the regulatory infraction was resolved, then there's no longer a reason to detain the motorist. They have asked for that under the state constitution. That's the argument.
Okay, and I can grant, and in fact, what I typically try to say in the briefing is that in the absence of a development of an argument for a divergent interpretation under the state constitution, you should interpret them coextensively. And I, of course, recognize this court's right to apply federal principles in a more stringent fashion under the state constitution.
All right, well, let's get to the issue then. Is there a case where a police officer should just turn away and say, sorry, my mistake? Or can they continue to do a little subtle investigation? Is that reasonable?
So I have difficulty accepting either proposition as the point of departure, because the implication behind a subtle investigation necessarily ends in the state losing on a suppression issue, because we already know from Rodriguez and Pardee that officers may not expand the scope or duration of the search beyond the mission of the search or the mission of the stop, which is, as the Supreme Court has determined, includes the ordinary and routine inquiries that we've all come to expect will occur when an officer comes and says license and registration, please.
And Part E stands for that proposition, I think, but in part, the offenses were still being investigated, if you will. I mean, Part E, there were a couple violations of law. The stop was good. There was a couple violations of law. The officer was processing those violations of law, and as part of that, you can do name, rank, and serial number. This is a little bit different in that, I mean, it's more akin to the Illinois case, I gather. It's different in that the reason for the stop here, as I understand it, was no longer present because the officer determined that the driver was male. Now, maybe it doesn't make a difference. I mean, you might argue, well, so what? But it's a little difference in Part E, in that you don't have an ongoing, you don't have processing of an ongoing offense for which the stop was originally made.
We do have a difference, and I'll embrace that because I think it illustrates some of the logic and experience behind Rodriguez and Pardee that maybe helps make Rodriguez make a little bit of sense. Because practically speaking, if I have stopped somebody for a taillight violation, what in God's name does my insurance have to do with that? We'd have to start thinking a little bit about it. I think as a practical matter, there's both there's a connection that we would have to work for, okay? And then we have to recognize that those inquiries necessarily expand the scope and duration of the stop, all right? So if we're going to adhere to principle alone, then there's no reason for these routine inquiries into license and registration. That is to say, if you can get away with a stop without asking for license, registration, and insurance, and still do your traffic violation, then you have to do that if you follow.
But you still have the authority to be where you are and standing at the side of the window where you are, because you still have that reasonable suspicion going on.
Right.
So, sort of like, you go to church before you get to the sermon, you go through some, a process, and isn't that what the officers do? They ask you for your license, and that's a standard question, first thing you're going to say. But in this case, when the officer stepped to the window, he knew he was mistaken. So why would you go through the routine when you immediately knew that you were mistaken?
I think, let me answer in a couple of different ways, because it is part of the routine. It is what we have come to expect as members of the driving public when we've chosen to get a license and to go on the road. And there's an expectation among the rest of us that the other drivers around us are licensed, that is to say trained, that their vehicles are operable, and that they're insured in case they cause an accident. So it is, in a sense, for lack of a better expression, per se reasonable. We have a public policy, which is to say our societal judgment as articulated through the legislative announcement in 321-174, that everybody has to carry their license and they have to show it.
Let me ask a hypothetical. Can we do random stops based on no suspicion of any kind, but we're just going to randomly stop traffic and ask for driver's license and insurance cards with a view of kind of fishing?
Okay, and I think maybe the way I can answer your question is first by saying no, because we can't have just random stops, but we can have sobriety checkpoints. We could have, in fact, we could have registration checkpoints. We could stop every 5th car as long as we've got a pattern of practice for it. Okay. So the point, and maybe the necessary point, is there has to be an initially valid detention. Okay, and so long as it is an initially valid detention, then we understand and we accept it as reasonable that officers may ask the ordinary incidents, in fact, the only 3 inquiries, license, registration, and proof of financial responsibility, because that doesn't expand, that doesn't, in fact, to use another somewhat discredited nomenclature, it's de minimis.
Well, each one of those statements could lead to the commission of a crime. I mean, they directly could result, as it did in this case, to a different criminal charge being filed against a person totally unrelated for the reason for the stop.
And they could be unrelated to any other traffic infraction that does pan out, if you will. And I have to apologize in a sense. The way this case came up, it, illustrates the perils of relying on published authority. I cited Jackson and went on to the rest of my activities. And the Court of Appeals invited us to explore 3 other cases, Rodriguez, Pardee, and Cummings. And it wasn't until this weekend that I decided that if we are going to work on that wheel again, what does the rest of the landscape look like? And I won't pretend that there's a majority that supports the state's position, but I can say that it's about evenly split. And I think the state's position is aided by the Supreme Court's position, or it's essentially its conclusion, if you will, that irrespective of the arguable irrelevance of license registration and insurance to the reason for the stop in the first place, it's nevertheless acceptable and reasonable to ask a motorist, do you have your license? Do you have your registration and insurance? And then, if the motorist says, no, I don't have, like this motorist did, I don't have my license, well then you're on to a different chain of decision making.
Sure. Well, I mean, sure, and I agree with that. I mean, I think that's obvious. But the stop, I mean, you characterize it as de minimis, and I do understand that. But the stop is extended, both in terms of, I mean, there's no reason to ask any further questions, at least based on the purpose of the stop. I mean, you say it's de minimis, but both time and scope of the search changes. It seems to me, or the stop is really what we're talking about. Yeah.
And I have to grant you that that's self-evident.
Right. And then the question is I mean, then those cases, I mean, I've read the cases too, and some of them are not terribly satisfactory, and they're certainly divided, at least. And, whether it's 8-6 or what, it doesn't concern me much, other than to say that there's a diversity of opinion on it. But why is it? I mean, even in Pardee, we're talking about a few minutes. I mean, we're not talking about a very long extension, I don't think. And all the cases don't talk about a terribly long extension. But in Pardee, we concluded that extending a stop minutes, and a lot of the cases talk about minutes, and that is too far. Why do you say, I mean, you're kind of drawing the line, or you're kind of dismissing it as de minimis, and I guess I'm kind of trying to figure out why.
Well, in part because the cases tell me so, and in part because I think I recognize, as I've done frequently before this court, that I accept that there's a constitutional protection, there's a boundary to us all as we go along. What I'm saying is that I'm willing to call this a de minimis intrusion because while I might believe that as I go along in my car, it's my own personal avatar, I spend so much time in there that it's my second home on 4 Michelins. But I and many other people also think that when I get into the car, I know I gotta carry my license, and I sure as heck hope that everyone else is too. Because if you've been in an accident with somebody who doesn't have insurance or isn't licensed, things get extraordinarily complex for us. And so,
That's a good argument for having laws, registration laws, license laws, financial responsibility laws, and when there's reasonable cause to think they're being broken, by all means, law enforcement can intervene, but we didn't have reasonable suspicion here after the sex of the driver was identified. I think you agree with that.
I do. And let me make two clarifying points that I hope will assist the court. Sometimes it's not altogether clear who you're dealing with. And it might say that you're dealing with a white male, but that may not be evident to you when you come to the door. So you could have circumstances where reasonable suspicion will continue, all right? So that's one. Another thing to consider is, and this in some respects cuts for and against the state's position. There's the matter of the warrants check, okay? And my position now is that license registration and insurance has to do with highway safety. And we've developed a broad understanding that it's permissible, if the initial stop is okay and we're already there, it's permissible for police officers to ask for that. And I will grant that there is considerably more controversy over whether it's permissible for the officer to conduct a warrants check in that circumstance.
And why isn't it permissible to extend the search for a dog sniff? It'll only take a few minutes, and here we have a real public policy, right?
Right, and what I'm saying is that a lot of this ground, essentially this ground has been plowed already, and we can go around with it, but I think at the end of the day, it's essentially a diktat that these are reasonable inquiries, and it's difficult to logic your way through it. As with so many things in Fourth Amendment search and procedure, we're gonna at some point draw a line, and at the side, either side of that line, there are difficult questions, and sometimes they just don't make a great deal of sense.
Chief, could I ask one more question? What about officer safety as a reason to find out who you're dealing with, now that you already have them stopped?
Right, and I briefed that more extensively in the supplemental briefing, and I think in circumstances, and this record wasn't especially well developed on the point, which is another reason not to, if you will, go off on a lark. But I'm sure I will pay for that. But
Try not to go off on a lark, I agree.
there may be circumstances where you're going to say that the nature of that interaction suggests caution. And the officer who is in that position is in a different position, certainly than we are, in trying to make that decision. And his concerns, as I've said at various points, his concerns are corporal, and the motorist's concerns are constitutional. They're important. I won't walk away from that, but they are different. And for
Thank
these
you,
reasons-
counsel.
Thank you.
May I give you rebuttal, Ms. Meier?
In response to some of the things that Mr. Mullins had argued, the last thing that was discussed quickly was officer safety. We're presented with a situation where an officer comes up to a vehicle, especially in today's age. I believe the officer safety is critical. However, walking up to the vehicle, realizing that the officer has made a mistake, the officer saying, sorry, I made a mistake here and you're free to go, would certainly be less interactive and put the officer at less risk in the grand scheme of things. So as far as officer safety is concerned, our position would be that it would probably be more safe for the officer to say, I apologize, I've made a mistake, go ahead and go on your way. In regards to the warrants check that the state had presented, I don't know if the state's position is that now we're allowed to ask for to check for warrants as well as all of these other things, but again, where does that argument stop?
That's part of Rodriguez. That's in the list of the things that are part of the mission. Here again is my fundamental question about your position. In Part E, we said it's okay, there was a tail light that wasn't functioning. The officer stopped the car, always intending from the very beginning just to write a warning. So it seems to me by the rationale of your argument, what the officer should have done was approach the vehicle, say, here, I'm gonna warn you, you need to go get that tail light fixed, and let them go. Isn't that logically where your argument leads, if you're gonna take the position that the as a necessary part of the stop, or a permitted part of the stop, the driver's license, insurance, and registration check are not permitted?
I guess if I understand your question correctly, what you're asking is, should that be part of the entire stop as the warrants check? Is that correct?
No,
Okay.
yeah, and my question is that if you object to the officer asking for driver's license and registration and insurance in the case that you have, in your case, and I know you do, then by that same logic, shouldn't the officer and party have simply said, you need to get that taillight fixed, be on your way?
Well, the officer had stopped that vehicle because of the other traffic citations, the other traffic violations. When the officer walked up to the vehicle, he had reasonable suspicion or probable cause to stop the vehicle. With that being said, I believe that he could have appropriately addressed those issues. In my case, that's not the circumstances. The officer walked up and said, and realized that there was a male instead of a female sitting in front of him.
In both cases, you have a stop that's valid, and then you have, at some point, the justification for the stop ends. Now, why doesn't the justification for the stop end at the same point in both cases?
Because I think that the other case with the issuing the warnings, the officer didn't just stop at issuing the warnings. The officer went further and detained those individuals for too long. In my case, while I think it's different from Pardee, is that the officer actually waited for a dog sniff, is what I remember. And so that extended period of time, you know, it was just too long. And again, because there was some interaction between the drivers and the passenger and the officer, that just went too far. And again, in my case, it also went too far when the officer didn't stop when the reasonable suspicion, when everything had ended. Once he issued the tickets, everything should have ended. But that's not the case, and that's not what happened. And then as far as the warrants check, again, going back to that issue, so, you know, I don't know if it's the state's position that they believe that warrants checks should also be done, but, you know, does that fall down to walking down the street? Does an officer have the option of saying, oh, you know, I need to stop you and see do a warrants check on you? You know, where does that stop?
Well, doesn't that it still have to start with the initial stop has to be valid? They have to have a reasonable suspicion, whether it's a Terry stop of a pedestrian or pulling a vehicle over, and that's not an issue in this case, is it?
Justice, I see my time is out. May I answer that
You may
question?
answer the question.
Okay. In that particular case where there's a person on the street, no, I don't think that an officer should be permitted to do a warrants check. Additionally, I don't think that they should be allowed to do a warrants check with a vehicle as well.
Okay. Thank you, counsel.
Thank you.
The case of State versus Coleman then is now submitted to the court, and the bailiff may adjourn.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.